Hello, I'm Edith Zeller, Administrative Judge in Austria and President of the Association of European Administrative Judges. Today I would like to talk a bit about what is the relevance of separation of powers for administrative judiciaries and for us citizens. First, some words on administrative judiciaries. Whereas hardly any one of us will ever need to go to a civil court or criminal proceedings, nevertheless, many citizens will once in their life have to interact with administrative courts. For instance, be it because of building permit, because of plans permit, because of residence permits, or because of tax issues, unemployment benefits, social aid, whatever. Because this affects many daily issues in everyday's life. Therefore, administrative judiciary is somehow the face to the public to show judiciary. In addition, in administrative proceedings before administrative courts, we have a special standing of the parties of the case. We have always one private party, and the other party to the case is the executive power, the administration, a public power in the state. And the administrative judge has always to weigh private interests versus public interests. In addition, one of the two parties generally has more power than the other party to the case, which is the executive power, the administration. For instance, has generally more access to information, for instance, so it makes it more powerful. And even the more, it is important to make sure that we have equality of arms between the parties of the case. This is somehow also relevant for the administrative judge, specifically in administrative proceedings. So this is specifically some words on administrative judiciary as part of the judiciary, besides civil and criminal judiciary. Now some words on separation of powers. We all know, we always hear separation of powers. Oh, it's relevant for a country, a democracy governed by the rule of law. We know. So only some words. In every state governed by the rule of law, we need to have separation of powers. Which powers do we have? We have the legislator. This is the power in the country which makes the law which is binding for every citizen. We have the executive power, the administration. They implement and execute the laws of the legislator. And we have judiciary. For instance, the administrative judiciary is here to check and to make sure that the administration complies with the laws when it has executed the laws. And administrative judiciary is also here to safeguard the fundamental rights of every citizen, which the citizen has vis-à-vis the government or the state. So this is a principle of separation of powers which is relevant. And as we see, within these three state powers, we have different mechanisms to make sure that there is a checks and balance system, because these three state powers, one against the other, has a specific mechanism in order to make the checks and control the other state power. And this should be balanced. In balance to make sure everything's okay, that every state power controls the other. This is a democracy, and this is a separation of powers and rule of law. However, in the last years there has been a certain trend in some European countries which has brought this checks and balance system into a certain imbalance, so that it's no longer proportionate. We will talk about it in detail later. Only some input. First, the trend not to execute judgments has increased, which means, for instance, when a judge says, no, your administration must issue a residence permit, but the administration does not do anything, then that's a problem with the execution of the judgment. Or, for instance, we have seen certain tendencies that the executive power gets more influence in issues of administration of justice, purely administrative issues. But as we know, administrative issues have also certain consequences. And the third imbalance, which has more and more taken place in many European countries, is that the legislative power and the executive power are more and more interrelated. They are a bit intertwined. It's no longer a proper checks and balance in between legislative power and executive power. Not really. And there's a certain tendency that they are more and more combined. So this brings with it insofar an imbalance, because it's only the judiciary left to do its part of the judicial work and to do its part to do the checks and balances. As you see, then that whole checks and balance system is imbalanced and no longer proportionate. These are some problems about which we are going to talk later. However, this was relevant to tell how important it is to have a proper separation of powers, to have a proper checks and balance system. We need to have it in order to have a state governed by the rule of law, in order to make sure that we all live in democracies and that our democracies can flourish. And this shows that administrative judiciaries and judiciaries as such play an important role in this whole game. And we see how important it is that courts must be independent. Otherwise, it would not be possible to fulfill the role in this checks and balance system. And we can see that it is important that the independence is safeguarded by sufficient safety locks, so that it's not so easy to crack them in order to get influence on judiciary, because judiciaries must do the checks and balance system. And next time we will talk about what is a concrete example for this imbalance of checks and balances. How do we recognize that there is a problem? And later on, we will talk about ways how to make it better again, how to bring it back to balance. For today, thank you very much.